Hello, good afternoon, everyone. My name is Layla Pilgrim. I am the Secretary to the Post Office Horizon IT Inquiry. I see many familiar faces here, so some of you I already know. On behalf of Sir Win Williams and the wider inquiry team, I would like to wish you a warm welcome to this launch event. Before I say anything more, and I will be brief because I do know that Sir Win is the main act, not me, I just wanted to introduce you to the people who are seated at the table, some of whom may be familiar to you, but others less so. At the far left, as a member of the inquiry team, the solicitor to the inquiry, Mr. Shegan Jide. Next to Mr. Jide is Mr. Jason Beer, KC. Next to Mr. Beer is Erica Eliasson Norris, who is one of the assessors in the inquiry. Sir Win Williams is well known to you and is the chair of our inquiry. Mr. David Page is the other assessor who, together with Erica Eliasson Norris, has accompanied Sir Win when sitting in person, but they have also been part of all of the hearings when they took place remotely. As many of you know, earlier today, this event began with the lock-in sessions where court participants had an opportunity to see the report and to read it under embargo before it was laid in Parliament and then published on our inquiry website. This second session provides an opportunity for Sir Win to make a few remarks. Two things before I introduce Sir Win. Firstly, he will not be taking questions after he has spoken. And secondly, please do not leave when this part of the event is over. We have prepared lunch, not personally, but we have prepared lunch for you, and that will be served at 1 p.m. But anyway, I am mindful that I stand between you and hearing from Sir Win, so without further delay, Sir Win Williams.
Before I begin the formal part of my speech, you can see that I've surrounded myself with a Praetorian Guard, just in case. It's very good to see so many people attending this event. I've always been extremely grateful for the interest that everyone has shown in this inquiry, not least, of course, the people most directly affected. But there's been a wider interest as well, and I'm very grateful for that. And so I wanted to start what I have to say by thanking everyone publicly for participating in the inquiry so far. Now, those of you with good memories may remember that I've made video-recorded speeches about aspects of the work of the inquiry on 2 occasions. The first video was made available as long ago as the 30th of September 2022, shortly before Phase 2 of the inquiry got going. The second became available on the 17th of July 2023, the day my interim report was laid before Parliament. In each of those videos, I emphasized the importance of 2 strands of investigation which were inextricably linked and which would be crucial parts of the work of the inquiry. Those strands were: 1, discovering and explaining the nature and extent of the adverse consequences suffered by so many as a result of the misplaced reliance upon the dependability and accuracy of Horizon, what we've come to call in this inquiry the human impact. And 2, discovering and assessing whether the Department for Business and Trade and the Post Office had made good or were making good upon the often repeated assurances from ministers, departmental officials, and senior personnel within the Post Office that financial redress for those who had suffered adverse consequences would be full, fair, and prompt. Over the nearly 3 years since I first highlighted those strands of investigation, nothing has occurred which has led me to change my view of their importance. It should come as no surprise, therefore, to those who have been following the progress of the inquiry that as soon as I had completed the oral evidence gathering phases, I turned my mind to whether I should deal with the issues of human impact and redress as part of a much larger report, or whether I should produce a part of my report, Volume 1, dealing discreetly with human impact and redress as soon as it was written. As will now be obvious, I chose the latter course. I chose this path because it is essential, in my view, that I provide a detailed report about the schemes which have been developed to deliver financial redress as soon as I reasonably could. That way, I would be able to report upon how they had performed historically and also attempt to predict how they were likely to perform going forward. Having heard and read a very substantial amount of evidence, I concluded that some aspects of the schemes could be improved substantially. In those circumstances, it made no sense for me to wait until the whole of my report had been completed and was ready for publication before revealing my views. However, I was also firmly of the view that a report which considered and reached conclusions about the schemes without first describing the adverse consequences which gave rise to the need for redress would be sadly lacking in context. I appreciate, of course, that much has been written and said about the adverse consequences suffered by postmasters and others over the last 25 plus years. Nonetheless, in the early months of 2022, I heard sworn evidence from a large number of people who allowed themselves to be questioned about deeply personal issues in the full glare of a statutory public inquiry. Throughout the whole length of the inquiry, I have received written evidence and other sources of information about the nature and scale of the human impact visited upon so many. The picture which has emerged is profoundly disturbing. It would have been wholly wrong of me to present this volume of my report without describing in some detail the human suffering which has given rise to the need for complex schemes for providing financial redress to those who have been wronged. Let me turn then to describe what this volume contains for those of you who have not yet seen it. Following an introduction, I list my recommendations. The introduction and the list are sections 1 and 2 respectively. Section 3 is devoted to human impact. It has 3 subsections: a short introduction, a summary of the main types of impact suffered by the various categories of people who are adversely affected, and then there are 17 case illustrations, which I chose because it seemed to me that between them, they provided a cogent basis for all or virtually all of the adverse consequences which I'd already described. I acknowledge the possibility that the case illustrations may contain the odd factual inaccuracy. I say that because in the main, they are based upon the recollections of persons who are seeking to describe events which had occurred many years ago and often without contemporaneous documents to prompt their memories. But such inaccuracies as exist do not matter. The case illustrations are intended to paint a very broad but compelling picture of the type of harm which very many people have suffered. I am completely satisfied that they achieve that purpose. As I have said once already, but I repeat, the picture which has emerged and which is described in my report is profoundly disturbing. In summary, what does that picture reveal? Many thousands of people have suffered serious financial detriment, and for a sizable proportion, that detriment subsists. Many people have, inevitably, suffered emotional turmoil and significant stress in consequence. Many businesses and homes have been lost. Bankruptcies have occurred. Marriage and families have been wrecked. Between 2000 and 2013 in England and Wales, and for some time after 2013 in Northern Ireland and Scotland, postmasters and others suffered the trauma of criminal prosecution, conviction, and punishment. And for some, punishment meant lengthy periods of imprisonment. I received reports that some people held liable for shortfalls became ill as a consequence. Tragically, I heard too of people of whom it is said that they were driven to take their own lives. Section 4 is a very long and detailed section which contains a summary of the evidence which I heard and read relating to redress. I readily acknowledge that it is a difficult read for all except the most committed. It deals primarily with the schemes which have evolved for delivering financial redress to those who are entitled to it, but also covers other discrete issues which relate to financial redress. The section ends with a short section on restorative justice, a concept with which I was until it was introduced to me in this inquiry. In Section 5, I identify those core participants from whom I have received written and oral submissions about financial and other forms of redress. And then we have Section 6, which contains my conclusions and recommendations. Early on in that section, I pose the following question. Have the Post Office, the Department and ministers delivered financial redress to claimants which is full and fair, and have they done so promptly? In much of the remainder of that section, I set out my answers to all the component parts of that question. Before spending a few minutes summarizing some of those answers, however, let me explain how Section 6 begins. No more than a few lines have gone by before I make my first recommendation. And that says this: His Majesty's Government and or the Department, and where appropriate the Post Office and Fujitsu, shall provide written responses to my recommendations by the 10th of October, 2025. Some may think this recommendation is some kind of challenge to the government in general, the department in particular, the Post Office and Fujitsu. It is not. Rather, I categorize it more in the nature of a plea by me to all those who need to make decisions about my remaining recommendations to do so as quickly as they can. It would not be appropriate, in my view, to kick the can down the road and wait for the remainder of my report before deciding about whether to accept my recommendations. I suggest that a period of 3 months in order to make a decision about whether to accept or reject them is quite sufficient in all the circumstances. All the recommendations formulated, except that first recommendation, and numbers 17 and 19, are concerned with the schemes for financial redress. If my recommendations are to have their maximum effect, decisions about recommendations 2 to 16 and 18 must be made swiftly, and if, as I hope, of course, the recommendations are accepted, the sooner they are implemented, the better. What are some of the conclusions that I have reached about the schemes for providing financial redress? This is a thumbnail sketch. I'm afraid if you want the real meat of it, you will have to read Section 6. I'm going to deal with each scheme in turn and quite shortly. First of all, the Horizon Shortfall scheme. This scheme has always been administered and delivered by the Post Office, although to a degree the department has pulled some strings too. Between May 2020 and the 30th of July 2024, all claims were assessed. The picture which emerges in relation to settlement within that period is as follows. A high percentage of the most modest claims were settled for the sums which were claimed, or for sums very close to those which were claimed. Whether some of those settlements were in reality full and fair can only be a matter of conjecture. Many claims in the brackets 20,000 to 60,000 were likely assessed at sums which were not full and fair. On the available evidence, I cannot confirm that a majority of high-value claims which were resolved on or before that date, the 31st of July 2024, were settled for sums which were full and fair. On any view, many of the larger claims have proved very difficult to settle. To illustrate that point, as of the 30th of January of this year, there were 314 claims which had been submitted between May 2020 and the 27th of November 2020, but had still not been settled. A large proportion of those claims have been and continue to be very difficult to resolve because of their complexity and potential value. A fixed sum offer of £75,000 has been available to claimants since the 31st of July 2024. A significant number of claimants have opted to accept that sum. It is widely acknowledged that some of those claimants will have received sums which exceed the true value of their claims. It is as yet unclear whether the claims which have been assessed since the 31st of July 2024 have resulted in settlements which it would be proper to categorize as full and fair. As of the 30th of April of this year, HSS, as I'll use the acronym for shorthand form, had received 9,437 eligible claims, 6,644 offers had been made, and 5,812 had been accepted. Those in my legal team who assist me to keep track of recent events have discovered that HSS had received a total of 887 eligible claims by early June. There had been 7,188 offers and 6,426 acceptances. There are still more than 3,000 claims to resolve, and the likelihood is that there are approximately 1,500 complex and standard claims which are either in the process of assessment or waiting for the process to begin. In my view, if HSS is closed, as I recommend it should be, on the 27th of November of this year, a number of years would still be necessary to deal with all the claims which would be unresolved on that date. On any view, there have been egregious delays in HSS for which the Post Office and the Department have frequently apologized. The overturned conviction scheme and the more recently announced Horizon Conviction Redress scheme. Until the 3rd of January, OCS, as I call the overturned conviction scheme, was administered and delivered by the Post Office. 111 persons have had their convictions quashed by the courts and are eligible for financial redress. 3 persons who were prosecuted but not convicted are also eligible for redress under this scheme. It opened in July 2021, following the quashing of convictions in December 2020 at the Southwark Crown Court and in April 2021 at the Court of Appeal Criminal Division. Interim payments were made promptly to those whose convictions were quashed, except for 3 claimants who were denied interim payments, unfairly, in my view, on what was described as public interest grounds. Between the opening of the scheme and the publication of my interim report in July 2023, there were a number of partial settlements, especially relating to non-pecuniary losses, but there had been no more than a handful of settlements of both pecuniary and non-pecuniary losses. In September 2023, a fixed sum offer of £600,000 became available to those in this scheme whose convictions had been quashed. I understand the current position to be that 71 claims have been settled in full, 62 claimants have accepted the fixed sum offer of £600,000, and 9 claimants have had their claims assessed and accepted offers in settlement following assessment. That figure includes 1 claimant who was prosecuted but not convicted. 13 claimants have yet to submit particularized claims, and the remaining claims are in various stages of partial settlement or negotiation. It is impossible for me to tell you whether the settlements so far achieved can be categorized as full and fair, since I have not thought it appropriate to compel evidence from individuals about their settlements, and very little information has been volunteered by the claimants, who obviously value their privacy. The more recent scheme, which I'll call HCRS, was constituted as a discrete scheme administered and delivered by the Department in July 2024. It was set up to deliver redress to those whose convictions were quashed by legislation. The fixed sum offer of £600,000 has been a feature of HCRS from its inception, and so far as I am aware, all claimants whose claims have been settled, or at least who settled prior to the 3rd of June 2025, opted to accept the fixed sum offer. On the 3rd of June 2025, the overturned conviction scheme was amalgamated with HCRS. From the date of amalgamation, the scheme has been administered by the and delivered by the Department. The amalgamation of those 2 schemes was obviously sensible, which I suppose begs the question: why were there ever 2 distinct schemes for claimants whose convictions had been quashed? One operated and delivered by the Post Office, and one operated and delivered by the department. OCS has not been without unjustified delay. The time taken to formulate pecuniary principles was described as a tortuous process. That is, in plain English, it took far too long. Furthermore, the process to formulate those principles did not begin until approximately 18 months after the scheme had been announced. The Group Litigation Order Scheme, GLOS, was set up to provide financial redress to those claimants who had been party to the group litigation brought against the Post Office and which was settled in late 2019. As is now well known, the claimants in the litigation appear to have won a famous victory. Unfortunately, the compensation they received under the deed of settlement did not properly reflect their losses. After a period of reflection, the government of the day agreed to provide funds so that additional financial redress could be made to those claimants. The scheme was announced in March 2022. Unfortunately, a year went by after the announcement before the scheme was opened. It has always been administered and delivered by the department. There are potentially 492 claimants. By the 30th of April of this year, the number of fully particularized claims submitted to the department stood at 450. 445 offers had been made, of which 304 had been accepted. 42 claimants had not submitted their claims. By my reckoning, as of the 30th of April 2025, there were 146 claims unresolved. My team tell me that at least 4 further claimants have submitted particularized claims by early June, but that would still leave 38 claimants who have yet to start the process of presenting a claim. A fixed sum offer of £75,000 was introduced in this scheme in January 2024. Of the 304 claimants who had accepted their offers by the 30th of April 2025, approximately 50% opted to accept the fixed sum offer, with obviously the same percentage or thereabouts opting for assessment. I have received no information about individual settlements, although I have been made aware that a number of claimants have expressed their unhappiness with the level of offers made to them. You should know that people continue to correspond with me right up until very recently about these matters. The likelihood is that most, if not all, of the claims which are unresolved are to be assessed. That means, in my view, that there is a great deal of work to be done if these cases are to be resolved satisfactorily within any kind of reasonable timescale. I say that because it appears clear that in many cases in which assessment is taking place, the valuations placed upon the claims by the claimants and their advisors, on the one hand, and the departments and its advisors on the other, is markedly different. I would like to emphasize that a number of recommendations which I make are aimed at removing some of the obstacles which currently exist along the path to achieving settlements which are full and fair. Even if the recommendations are accepted and implemented swiftly, however, it is difficult to imagine that the unresolved cases can be settled anytime soon. I am loath to predict when all the claims in that scheme will be resolved, but I very much doubt whether settlements of every claim can be achieved before the end of next year. To repeat, there are likely to be 150 claims or thereabouts in the process of assessment, which is a large number still. There is one last point which I wish to stress about each scheme. Although it is correct to say that the schemes are administered and delivered by either the post office or the department, everyone should understand that the persons who ultimately decide upon the awards to be made to claimants are not employees of the post office or the department. In both HSS and the group litigation scheme, the ultimate decision makers are independently appointed panels of appropriate experts. If their decisions are flawed, there is an entitlement to seek a review before a very experienced retired judge. In fact, there are 2 judges, one for each scheme. Those whose convictions have been quashed, that is, the claimants in OCS and HCRS, are not obliged to accept offers made to them by the department. They have preserved rights to seek redress in the courts. I turn finally to say something about my recommendations. Recommendations 2 to 16 all relate to the existing financial redress schemes. They are all intended to improve these schemes, but I readily accept that even if my recommendations are accepted and implemented as quickly as I would like, they will not constitute some magic formula for removing all of the problems from which the schemes suffer. As my report makes clear, I am critical of the Post Office and the Department in relation to the development and evolution of these schemes in a number of important respects, not least in relation to some of the egregious delays which have occurred. I cannot say plainly enough that there should not have been 4 distinct and separate schemes for delivering financial redress. It is true that recently 2 of the schemes have been merged so that the number of schemes with which I am concerned is 3, but that improvement is likely to make very little difference to the time it will take to provide financial redress to all claimants. However, to use that ultra-modern phrase, we are where we are, and I, for one, cannot imagine scrapping all the schemes and starting again. Such a step would likely add many years to the period of time which would elapse before redress is paid out to all claimants, and I cannot contemplate that. I do not propose to discuss in what I thought would be a short speech, but seems to be longer than I anticipated, the substance of the recommendations 2 to 16. The details of each of the schemes are set out in section 4 of my report, and the reasoning which underpins each recommendation is set out in section 6. That said, I would like to make 2 points. First, many of the recommendations are directed at the Horizon Shortfall scheme and the newly created appeals process within that scheme. And accordingly, those recommendations should be viewed and considered as a package and not just individually. I make it clear that I share the view of the Business and Trade Committee that the Horizon Shortfall scheme is the scheme which is in most need of remedial attention. That, of course, is not surprising, given that it has had to handle close to 10,000 claims, and there may yet be many more to come. There can be no doubt that but for the availability of the fixed sum offer in that scheme, it would have been overwhelmed. Second, recommendations 2, 3, and 5, which apply to all schemes, and recommendations 11 and 12, which apply to the group litigation scheme, are made so as to seek to ensure, so far as possible, that the main processes in each scheme are at least similar or broadly comparable. That leaves recommendations 17, 18, and 19. I have been persuaded that the victims of wrongdoing and the public at large will never be convinced by words from lawyers that financial redress schemes which are administered and delivered by the alleged wrongdoer are truly independent. Furthermore, with the growing appetite which undoubtedly appears to exist for redress schemes to operate without reference to the courts or a formal arbitration structure, it is, in my view, necessary to create a body which has the expertise and capability to administer and deliver redress schemes which are, and are seen to be, wholly independent of the public body alleged to be responsible for the wrongdoing which has created the need for redress. However, and this may disappoint some, let me stress now that I do not believe that such a body could be created sufficiently quickly to make it viable for that body to take over the administration and delivery of financial redress in the existing schemes. Recommendation 17, if accepted, must be implemented with considerable care and with a clear set of objectives laid out from the start. As will become obvious from a careful reading of my report, there are literally thousands of claimants in the Horizon Shortfall scheme who are waiting for their claims to be assessed, and some of those, and there may still be more than 300, have been waiting for 5 years, and there is still no end in sight. There are claimants in the overturned conviction scheme whose convictions were quashed by the courts in 2020 and 2021, who are still to be fully compensated. And there are still about 150 people who are parties to the group litigation who are waiting for the assessment process to run its course. I do not believe there is any justification for all those persons to be put on hold while a new body is created. As I describe in my report, the existing schemes are flawed, but in my view, the schemes can be improved significantly, says he, if my recommendations are accepted and implemented. Let me say a word about recommendation 19. As I have implied, the phrase restorative justice was new to me when I began my work on this inquiry. Yet as the work of the inquiry gathered pace, and particularly during the course of the hearings last year, the call for measures which are associated with the umbrella phrase restorative justice became louder and more persistent. The Post Office and Fujitsu embraced the concept with what I might describe as varying degrees of enthusiasm. I was left with the impression, however, that they would both at least consider what sort of package of measures would be appropriate. Yet to date, I have heard nothing, hence the need for a specific recommendation. In my view, departmental involvement in this process would also be very welcome. I have said nothing about recommendation 18 as yet. Without doubt, I found the issue of financial redress for family members to be very difficult to resolve. I have been acutely conscious of the difficulties which family members would face if they were seeking to pursue claims against the post office, the department, or Fujitsu in the courts. That said, I am also mindful that these schemes are not and have never been constrained by established legal principles. Accordingly, I have reached the conclusion that fairness demands that financial redress should be provided for those family members who have suffered serious adverse consequences as a result of the treatment meted out to their loved ones. I'd like to conclude by paying a special tribute to all those who have helped me compile this first volume of our report. They are here, they are in this room, they are all the lawyers who made compelling submissions to me. The inquiry, I trust, has gone smoothly to date, and in huge measure, that is down to you and not me. Thank you very much. Enough. It's time for lunch.
Everybody, and welcome to this session of the Lords Justice and Home Affairs Select Committee, and we're absolutely delighted that we have with us today the Home Secretary. And just before we begin, and for the record, Home Secretary, if you'd be kind enough both to introduce yourself and the officials who've joined you.
Thank you very much for having me, Lord Foster, and thank you to all of the committee. I appreciate your time this afternoon. I have with me Simon Ridley, who is the second permanent secretary in the Home Office, and Richard Clark, who is the director for Safer Streets as well. So we can cover a wide range of issues that you want to raise.
It is certainly our intention to cover a wide range of issues. If we can just start off. We've recently seen your department has been told it's got to find a 1.7% cut per annum in future years. You've talked about making 5% savings and so on. There's also a concern, given government's recent decisions in relation to U-turns over benefits, that further cuts might have to be made. How are you going to deal with the cuts in the department?
Well, obviously, there are always challenging decisions around budget allocations, and those apply right across government departments to ensure that you get value for money. In the Home Office, we've set obviously clear priorities around national security as part of the foundation for the Plan for Change, as part of the Safer Streets, which is a mission for the government, and also around border security and restoring order to the asylum and immigration system. So we have a series of areas that we are prioritising. In terms of the overall funding issues, of course, we're unusual in the fact that we want to make very substantial savings from asylum accommodation. Under the previous government, there's a big increase, a multi-billion-pound increase in the funding being spent on, particularly on asylum hotels, but on asylum accommodation more widely, as a result of the sort of disorder in the asylum system. So part of our programme to ensure that we can make savings will be making sure that we are delivering on our commitments to end asylum hotel use over the course of the Parliament, and to make sure that we're making savings on asylum accommodation.
That's helpful, and that very specific point we will be returning to in some detail a little later on. But can I just, in the meantime, talk about, I mean, we've obviously done our research, and we've been looking at what other people say about the Home Office. We've heard concerns about record keeping, data management, lack of institutional memory, the inability to do horizon scanning, a lack of coordination between different parts of the Home Office. And only this month we've had, for instance, the PAC report, which has been looking at the management of skilled worker visa route. And that report talk of a lack of risk assessment, poor understanding of whether visa holders actually leave when their visa comes to an end, poor communication with customers, lack of having any real ambition for customer satisfaction, out-of-date IT systems. I could go on. Those are all the comments about your department. And you've been not only now for a while the Home Secretary, but prior to that you were the chair of the Home Affairs Select Committee. So in light of your previous experience and now in the role, do you think that the Home Office is fit for purpose?
Well, I think we've obviously inherited a Home Office just a year ago, where I do believe that a whole series of really chaotic decisions have been taken. The immigration system is a very good example, where net migration quadrupled in the space of 4 years. That was a lack of any proper grip on the immigration system, where we obviously had the serious problem around criminal gangs able to take hold along the channel in terms of the organised immigration crime. And I think a detachment from policing and crime, which allowed a situation where neighbourhood policing had been decimated over many years, And some of that a lot of those things were policy decisions made by the previous government, but policy decisions that then had implications for a sense of a lack of grip. So the work that we've been doing since the election has been working to turn a lot of those things round. So the Immigration White Paper, for example, addresses a lot of the things you've just raised as part of the PAC report. And I agree with a lot of the conclusions on the PAC report. They were about the long-term history around the immigration system, lack of proper data on entry and exit. The Immigration White Paper set out not only much stronger measures to bring in new controls around skilled worker visas, for example, new controls around the immigration system that had frankly previously had allowed this big increase in a very short period of time. So introducing those controls, but also a programme to roll out effectively a digitalisation of the borders, so the introduction of e-visas and new approach to entry and exit checks that allow us to have a much more data-driven analysis of who is entering the country, who is exiting the country, who has overstayed their visa, and therefore what enforcement action is needed. So I think the Immigration White Paper does respond to a lot of those things in the PAC report. Of course, there is a lot more to do, and there are lots of different areas in which we can discuss what further action is needed.
Thank you. Unfortunately, time doesn't permit us to go into all of those issues in detail, although there's many I'd love to pick up with you. But if we move specifically to the Immigration White Paper and some of the comments you've made. Lord Dubs.
Yeah, Home Secretary, we've been looking hard at the Immigration White Paper, and in paragraph 152, you say you will ensure that Parliament sets the boundaries for the reform of Article 8 within our international obligations. Why have you decided that individuals no longer need the protection of Article 8, and have you discussed the impact of the proposed reforms with the EU and its implications for UK-EU cooperation via Part 3 of the Trade and Cooperation Agreement?
We continue to abide by international law. The issues around the family routes, really, to the UK is we have a situation at the moment where, although there is a framework set out effectively by Parliament through the immigration rules and so on for family routes to the UK, it has really become very complex over extended period of time, and increasingly a very high proportion of cases are being decided as exceptions outside the rules rather than according to the rules, and effectively being decided through different court interpretations around Article 8 rather than us having a proper, effectively parliamentary debate about how Article 8 should be interpreted. As you know, Article 8 around family life is also qualified, it's a balancing, right? And it means that you, of course, need to take account of other issues, for example, the rights and responsibilities of governments and countries to control borders, to manage public finances, to manage national security, all of those sorts of issues as well. And what we think we need is a much clearer, better framework determined by Parliament that sets out how Article 8 should be interpreted in the courts in order to deal with some of the individual cases where there is real concern about perverse conclusions. We'll need to set out proposals for that later on this year, and obviously to consult on them as well in order to ensure that this is done properly. But I think to carry on with a situation where increasingly high numbers of cases are being decided as exceptions to the rules rather than according to the rules suggests that we've got the balance of the system in the wrong direction.
Thank you.
Can I just ask for greater clarity here? If you're saying that Parliament is going to be involved in a discussion about the interpretation of Article 8, that will then presumably lead to a statement about how Article 8 is to be interpreted. What is the process of ensuring that the EU are comfortable with that interpretation before it is accepted? Because you made a commitment back in May with the EU about ECHR.
Well, obviously the ECHR is separate from the EU, and other European countries are also signed up to international law, to the convention, and so on. So other European countries are also having exactly the same debates about the way in which different aspects of international law should be interpreted within their own systems. We already have areas where, for example, the 2014 Act, I think, where we have legislation that sets out the way in which different aspects of international law should be interpreted. But actually that goes back to 2014, that's 11 years ago now, and a lot of things have changed since then. So we should be able to refresh those debates and make sure that we've got a new, clear framework for how we think some of these balancing rights should be interpreted.
Okay. Baroness Brashar.
Thank you. Good afternoon, Home Secretary. My question is about indefinite leave to remain. As you know, the qualifying period is to be increased from 5 to 10 years. And for people already in the UK, you've said that you will publish the transitional arrangements after consultation has taken place. But I think for those already close to 5-year period, this has caused uncertainty. So I think it'd be useful to know when will they know, and how does this work in relation to the points-based system? Because looking at the press release, which was issued, accompanied by the Downing Street, it said that under new framework to be rolled out, high-skilled, high-contributing individuals who play by the rules and contribute to the economy and society will be fast-tracked, such as nurses and so on. So I think this has caused confusion. So I think it would be helpful to get clarity in terms of how will this work in practice.
So again, this is an area where we need to set out detailed proposals for consultation. So we set out in the Immigration White Paper the concept, the approach that we want to take, which is that settlement and citizenship should be earned, that it should reflect the sense of contribution to the country, and therefore, whilst the standard period would be 10 years, in order to be able to apply for settlement, then actually if there is a contribution, then that could be reduced to the country. We need to set out the detail of how that needs to work. You're right that that does mean that we need to also ensure that there are transition arrangements in place for those who are currently here working and contributing to the UK. And we also can reassure people that obviously everybody can continue to reapply and have visas renewed at the same time, and also that this will take time to implement. This is not something that will be introduced tomorrow. It needs proper consultation on the detail, including on the detail of the transition arrangements. So I completely recognise your questions and concerns, but part of the reason that we have said in the white paper that we need to set out more detail is in order to make sure we consult and get the details right.
Is there a time scale for that? And the other thing I want to pick up, if you could unpack for me the concept of earned settlement and earned citizenship. You know, how do you communicate the difference to ordinary mortals, you know, who are waiting for decisions?
That's what we need to do as part of the consultation. So we'll need to set this out, the consultation later this year. So it will be this year rather than next year. We will set those details out later this year. And there are factors you could take into account, including the contribution, working in this country, working for the National Health Service, for example, working for paying taxes in this country, obviously abiding by the law, extremely important that we take seriously, that those who come to the UK and want to make the UK their home need to respect the rules and respect the laws of this country, and we need to make sure that that is taken into account as well.
I mean, I understand the rationale for why you're trying to do this, but I think the concern that I'm trying to get across to you is that those who are nearing that 5-year period, they want some clarity. And if the consultation takes place maybe within this year, what happens to those people in between now and when the consultation is completed?
And the existing rules apply.
Existing rules will apply.
The existing rules apply. We are not changing the rules in advance of any consultation. We will put out detailed proposals. We will then have a consultation period. Then there will be an implementation timetable. and there will be transitional arrangements. So for anyone who is currently in the situation, the normal current existing rules apply that we have inherited that have been in place for many years.
My other question is...
Baroness Prashad, I'm really sorry, but I mean, I have received, and I'm sure many parliamentarians in both the Lords and the Commons have received letters from people who are particularly concerned about this 5-year to 10-year change that's taking place, not necessarily agreeing or disagreeing with it, but asking where do they stand. What I've heard from you is you will consult, there will then be a transitional arrangement, then something will happen. I haven't heard any indication at all as to when the consultation is even going to begin. I mean, is the consultation paper prepared?
Yeah, the consultation paper will begin before the end of this year.
What you said, yes.
By the end of this year?
Before the end of this year.
So potentially not until December 2025.
We will set out the timetable in due course, as you will know from your experience of consecutive governments. It is an unwise minister to give a precise month for documents to be published.
Well, with respect,
when, as you know, the Whitehall definition of seasons in the year is often rather different from what other people define as the seasons of the year. So I'm giving you the assurance that we will publish it in the course of this year. We will do so as soon as we possibly can, but we will do so certainly before the end of the year.
But you're also saying that the current rules will continue to apply.
Current rules will continue to apply until there is a formal change. So we need to go through a proper consultation on this. At the end of the consultation, we will set out the implementation timetable, including transitional arrangements. So the reality is that anybody who is coming to the end of their current 5-year settlement, their current 5-year visa period under the settlement rules, will be covered by existing rules.
Right. I have one other question. The white paper also commits to refresh of the life in the UK test and how it operates. What's the timetable for that process, and what's the purpose? And will the emphasis shift, from contributing to society and so on? I mean, what's the rationale for that, and which direction are you intending to move?
So it's been in place for a long time, so therefore it feels appropriate and timely to refresh that as part of an approach to earned citizenship and earned settlement, because to have a discussion about earned settlement and contributions without taking into account the existing tests would look a little bit disjointed. So we'll do it as part of the same process.
And are you wanting to shift the questions in particular direction?
Again, we will set that out as part of the process. Look, I completely understand. We have published recently an immigration white paper. That immigration white paper sets out a further series of additional steps. You're obviously asking me questions in between us publishing the white paper, which sets out the overall framework, including some areas where we've moved very rapidly to make changes. For example, this most recent immigration rules have brought in the changes to the skilled worker visa threshold on skills and also the healthcare visa. So there are some areas where we've moved very swiftly on implementation. There's other areas where we've recognised actually we need much further consultation and consideration before those changes can be introduced, and that will take time to set out.
Given the uncertainty, do you think there's a kind of a need for better communications of the transition arrangements and what happens between now until such time the consultation takes place?
Well, the current rules just continue to apply.
But that needs to be communicated.
That will find, you will find that in terms of on the website and on the Home Office website and the details that are provided by the Home Office. In terms of the next stage, we will obviously set that out in due course.
Just before we move on, what is your own view of the current life of UK test?
So, much as you might tempt me to set out the detail that we might put in our document before we do so, I will resist that, Lord Foster.
You must have a view, because if you've decided you're going to review it, presumably you're not entirely happy with it.
I think it's been in place for a long time, and I think it is appropriate for us to review and refresh it as part of the approach to earned citizenship, but we'll do that in due course.
Just off the top of your head, looking around the entirety of this room, what percentage of the current people in this room do you think would pass it?
Well, I don't think you're asking me to judge the members of the committee. I think that would be a very unwise thing for me to do. I think, look, it's been in place for a long time. I don't think it is up to date, and I also think it should be looked at as part of the earned citizenship approach.
Okay. Lord Douglas.
Yeah, thank you, Chair. Home Secretary, what are your proposals for the future of family reunion for refugees, especially children abroad who want to join family in this country?
So this is obviously something that you and I have worked on in the past over very many years. We think the overall family framework needs to change and needs to be looked at again, and that refers back to the point that you asked me earlier about Article 8. Specifically on family refugee reunion, we also have changes are being made in other European countries at the moment around family refugee reunion taking place in different countries as well that we also need to take account. So what I would happily do is write to the committee specifically on this issue. This is another of the areas that we flagged in the Immigration White Paper that we will take forward later on this year, be part of the wider consultation reforms later this year. There are some areas where we've been looking at whether there are more rapid changes as well. We have also been doing some work looking particularly at children reuniting with family, where, for example, we have had unaccompanied children in the UK who have reunited with family elsewhere as well, and looking at what that framework might be. Obviously, post the ending of the Dublin arrangements, we no longer have those arrangements in place, but there has been work done on really what are the most effective ways to make sure that the best interests of the child is supported.
Cool. Thank you. We're moving to a different area. Lord Filkin.
Secretary, can you hear me?
I can, yes.
That's good. Clearly, closer cooperation on border security is essential between the UK and EU and France in particular. Could you tell us what your ambitions would be for closer cooperation, referring to the one-to-one scheme, but also wider, if you would?
So, for the last 12 months, we've been working quite intensively with other European countries, but also more widely, in a series of areas to increase and strengthen cooperation. So particularly around irregular migration, illegal migration, and organised immigration crime. We held the first border security summit held in the UK a few months ago, which brought people together from all around the world to look at the way in which organised immigration crime effectively spreads its tentacles across borders. But because the gangs operate across borders, we need governments and law enforcement to cooperate across borders as well. And for too long, that hasn't happened. So some examples of things that we've done already is we have new cooperation strengthened with the Calais Group of France, Germany, Belgium, and the Netherlands and the UK in a series of meetings there. We have a new agreement in place with Germany, which includes the commitment by the German government to change the law around the facilitation of organised immigration crime, effectively allowing law enforcement to take action on the warehouses where we know that boats are being stored in Germany and where we know that the gangs have been really exploiting that loophole in the system. We've also been working closely with Iraq and with the Kurdish regional government, including drawing up new agreements between the UK, France and Iraq and the Kurdish regional government, because we know that a lot of the gangs that are operating in northern France are Iraqi Kurdish gangs that stretch their networks right back to the hills of Kurdistan, and we're increasing the National Crime Agency operations in Kurdistan, in Erbil and in Baghdad as well. So strengthening that operation across the board. Most specifically around France, one of the things we have been looking at in particular is around the maritime arrangements, where we've seen the gangs take advantage of the fact that the current French rules prevent French law enforcement from intervening in French waters. The French Interior Minister and I have both agreed that those rules need to change, and that's why he has instigated this maritime review and is looking at changing tactics, changing operations as a result. We obviously want to see that come into place as rapidly as possible in order to prevent boat crossings in the first place.
Thank you. That's quite a bit on process and quite a bit on what has been done, which is very interesting. And clearly, the last point is well covered in the media at present. So could you really focus a bit more on the question? What do you hope in the future should be done? And tell us about the one-for-one ambition and wider than that. It's a question about your ambitions for the future rather than the record of the past.
So the issues around the maritime review, that is obviously about changing the rules in the future. That is immensely important and is something that the French government are looking at the moment. The next area that we are working to strengthen, where we want the increased operations, is it's effectively a joint law enforcement operations and strengthening those. So we have started sharing far more intelligence on some of the organised immigration crime gang networks with not just France, with Belgium, with Germany, and accelerating that cooperation. We want to strengthen that coordination and also strengthen the work with Europol and with the Europol task forces in order to be able to go after those gangs. On the issues around returns, we've again been looking very widely over a long period of time around how we increase returns, how we ensure we increase returns, for example, to places like Iraq, how we look at some of the work that European countries have been doing around returns hubs, and also how we look at different issues now that we have lost the Dublin agreements that we used to have, and what kinds of additional returns that we could do as part of that process. But that work is still underway. So I understand the questions that you would like to pursue on that. That, again, may have to wait while the additional work we have is underway in how we strengthen those returns and how we strengthen that law enforcement cooperation.
Thank you. Turning slightly to a different topic.
Just Lord Filkin, just before you do, I mean, we're hearing rather a lot of things that are going to happen and things that you're planning to do. But in your thinking about these things, for instance, in terms of the returns of one-for-one, is the negotiation that you're going to have going to be with predominantly France, or are you going to widen that out to other countries who are clearly going to be affected? People return to France, then return back to other European countries where they first came in. I mean, that's all in this work that's going to be done, is it?
Well, with respect, Lord Foster, I think Lord Filkin just said, that's all very well, don't tell me about the things that you've done, tell me about the things that you're going to do. And I think you just asked me a question saying, hang on, you can't tell me about the things you're going to do, tell me about the things that you've done. Right. So I'm very happy to try and answer both sides of the same coin.
Very fair criticism taken, I'd still like an answer.
Indeed. I think, the work we have a lot of work underway with France. We'll set out the conclusions of different pieces of work as we work our way through. We've particularly been looking at the maritime issues, looking at law enforcement issues, and as the French Interior Minister has said some months ago, also looking at different returns arrangements as well. The approach that we're taking on this is we need to go after any different way that we can in order to prevent these dangerous small boat crossings, undermine our border security and put lives at risk. When you see these incredibly overcrowded boats where children get put into the middle of the boats, and we've had children being crushed to death on these boats, we need to look at absolutely every different approach to this, including strengthening the law in the UK, and that means including strengthening the law on endangerment so that we can go after people for these overcrowded boats, through to the new counter-terror powers so that we can investigate, through to new law enforcement cooperation, through to different kinds of returns arrangements, and bearing in mind that we have increased the returns of failed asylum seekers by nearly 30% since the election. So it's looking at the whole range of things that we need to do to prevent small boat crossings, but also to restore order and control to the system.
Okay, thank you. Lord Filkin, I interrupted. I apologise.
Thank you, and I'm grateful for the Home Secretary's help on trying to chair the chair. You'll understand. Home Secretary, turning to a more positive or a more optimistic topic, the youth experience scheme. I think many people welcome this. It's clearly not the full Erasmus, but at least it's a step in the right direction. When do you hope it'll go live?
So there will be a lot of more work to be done on this, and to be developed and negotiated between the UK and the EU. What was set out in the agreement, in the reset agreement, was around having a balanced scheme, which would be effectively time limited and capped, and also would have similar numbers of people travelling in both directions. That work still needs to be taken forward, because it needs to be taken forward together between the UK and the EU. The reset agreement obviously also referred to issues around the channel crossings, and some of that work we're taking forward at faster pace, because some of those security issues are particularly important.
So hopefully by 2026?
I can't set out the timescale at this stage. It will just be work that we take forward with the EU.
That sounds disappointing, but it might be 2027 then, by the sound of it.
I can't set out the timetable at this stage, but I'm sure we will provide regular updates, not just to the committee, but to Parliament more widely.
Well, without being trivial, there did seem to be quite a large distance between the UK position and France and the EU position. Are you optimistic you're going to close those differences?
I think, look, the approach that was set out in the agreement was that this will be something that will be agreed on all sides. Look, we have a different arrangement, don't we? We have different immigration arrangements. We are outside free movement, and we're staying outside free movement. France, Germany, other European countries have a system around free movement. So, of course, there are differences in the ways that we approach immigration system, and there will continue to be so. But the agreement as part of the reset was that the new arrangements would be drawn up to the satisfaction of all sides.
I don't want to press you too far, but we're aware that the world has changed radically in the last couple of years. Clearly, the scale of global security threats, the threats of invasion in Europe, let alone our own economic risks of absolutely flat productivity growth. We know it's essential we get closer to Europe, whether it's on security or the economy. It still sounds as if the machine is still fighting about the detail and the small picture stuff without really seizing that we've just got to get closer and faster and be better at compromising on both sides. Is that a fair statement?
No, I think the part of what we're all looking forward to today is the President Macron's state visit and his address here in Parliament. That is a sign of the very close cooperation between the UK and France. Certainly the French Interior Minister is the minister I have worked most closely with over the last 12 months. And on the economic side, I think having the trade agreements, the better trade agreements sorted with the EU has been hugely important for the UK, and is about how we strengthen those trading relationships as well. So I actually think the big picture that we've seen over the last 12 months is strongly strengthening the UK's role more widely on the international stage. The fact that the 3 trade agreements in place, the fact of the much closer partnership with other countries working more widely, and yes, particularly with our nearest neighbours, where that strengthens our economy, means we can deal with shared challenges around crime, around irregular migration, and in a series of different areas. So I think, look, we can, there's smaller issues, the individual focus specialist issues on individual policies where some of those will move at different pace to others. But I think in terms of the big picture, the work the Prime Minister's been doing actually on in those international relations has been incredibly important and really strengthening the UK's role.
Thank you. Last topic from me, if I could. The implementation of the EU's entry-exit scheme and ETIAS. It's great in theory. It's got considerable potential for going wrong and causing quite a lot of distress to UK citizens. I'm sure you're well sighted on these risks. What are you going to do as Home Secretary to try to mitigate them?
Yeah, so there's been a lot of work underway about trying to phase the implementation of some of the EU entry and exit systems to make sure that they are workable. Sima Malhotra, our Minister in the Home Office, has been leading the detailed work around agreement that we secured from the Commission and France for the Port of Dover to open a new coach facility at the Western Docks. Some of those really practical issues that we need in order to be able to manage those border checks away from some of the existing facilities. We've had further agreement on piloting, registering car passengers in different ways. So there's been a lot of work underway, quite detailed work, which I'm very happy to write to you about, or to ask Sima Malhotra to write to you about the detail. What we're trying to do is obviously we have alongside that work around the entry and exit system and trying to ensure that that is phased in a way that is workable, but also as part of the UK-EU reset, the support for e-gates as well, which will also, I think, smooth the passenger journeys into and out of the EU from the UK as well, and that support for e-gates. Alongside that, we're obviously strengthening the digitalisation of our own border for people coming into the UK, not just with the e-gate system, but also with the ETA and with the other e-visa arrangements, making sure we can get that better digitalisation of our own border as well.
Thank you.
Thank you very much. Clearly, in the light of that, you're optimistic it will go well.
I think there are always challenges involving major systems, and we are continuing to work to make sure that systems are in place and to keep that negotiation with other European countries on those.
Just before I bring in Baroness Hughes, Home Secretary, I'm sure you're aware this committee has looked at the issue of EES, ETIAS and our ETA on a number of occasions, obviously disappointed by all sorts of delays. But in relation to what's now been agreed, which is the phased introduction by the Schengen countries, there is contained within it a rule, or an agreement that says that at times of severe congestion, they can actually pause it anyway to ease that particular congestion. My simple question is this: who makes the decision to pause, and what ability do we, the UK, have in those juxtaposed border posts to make the decision to close EES, or will we not?
Well, EES is obviously an EU, it's a Schengen system. It's not our system,
No.
It's a Schengen system. I think in practice, though, the French government will not want a situation to build up where there are queues, for example, to Dover or to Calais, because as we know, the nature of the roll-on, roll-off journey is that difficulties on one side of the channel can very, very rapidly escalate to being difficulties on both sides of the channel. So we will need that to work effectively across countries. And we are continuing to engage both with the European Commission and the French government to understand their plans. Clearly, if this is about arrivals at an airport in Spain or in Germany and so on, those will be decisions for those countries. But you're right, the particular arrangements for us are around juxtaposed controls and how that is applied in practice. We are continuing to work with both the European Commission and the French government on how that needs to work in practice. If Simon wants to add anything more on that one.
It'd be very helpful if you got more.
So, I mean, I think the Home Secretary has set it out. I mean, I'm happy to wait for your follow-up. But we've got very close working relationships with the French Ministry of the Interior on this. We're doing that with the Department for Transport this side to make sure we have got the administrative arrangements in place that we need, focused very much on the juxtaposed controls.
Bearing in mind that we very often, in relation to transport going through the juxtaposed borders from the UK to the EU, we have much more information about the build-up of traffic and the potential for delay rather than the delay actually having occurred. And therefore it is really important that we have quite a major say in the decision. I accept entirely what the Home Secretary says, that this is a decision for the EU, and it will be particularly for the French staff operating at the juxtaposed borders. But the more say we can have in making decisions at peak times and times of potential chaos, it would be very helpful. And since we got the French President with us today, a good opportunity to just chat about it, surely.
Tell him.
I don't think they disagree with us on this one. I think this is an area we have a very strong shared interest.
We look forward to hearing more about it in answers to parliamentary questions in our House tomorrow. Baroness Hughes.
Thank you, Chair. Good afternoon, Home Secretary. I just wanted to focus for a minute on generally on Border Command and Border Force and get your views about whether they both have the capacity and capability to meet the government's aims for migration. And then specifically on Border Force, noting a review and actually evidence to this committee over the last 3 years that's identified significant problems in recruitment and retention, very high turnover of staff, problems with the training. Have those issues in Border Force been addressed? Are they up to a full complement of staffing now? And, what is the situation in terms of that issue of capacity and capability for Border Force specifically?
If I start with the Border Security Command and just update you on that, and then I might also ask Simon to add more detail on the latest in the recruitment for Border Force. The Border Security Command is set up to operate really in the same concept that when we set up the Office of Security and Counter-Terrorism back under the last Labour government, to be an overarching command that brings together all of the different organisations and agencies in the same way that we did with the Office of Security and Counter-Terrorism around countering terrorism 20 years ago. To take the same approach to border security now. So that includes Border Force, but also the National Crime Agency, police forces and so on. So overarching thing. The Border Security Command currently has over 200 people as part of its coordinating function, but obviously draws on the specialist investigators in the National Crime Agency, which we are increasing and recruiting, and also the intelligence officers who work as part of the Border Force as well. So that is how that is operating. And the Chancellor has announced an additional £280 million for the Border Security Command by 28-29. That will increase year on year, and we're already looking at increasing the recruitment this year, both around the Border Security Command and the National Crime Agency. In terms of the Border Force itself, because obviously the Border Force has to deal both with issues around security at our borders and also at the rapid facilitation of our borders for everybody going on holiday, coming home, coming here as tourists, and so on as well. A lot in those areas, we're doing the shift towards the digital borders, which means that we can better use border force staff for that intelligence-led and evidence-based issues around security as well. But if someone wants to then come in on some of the issues around overall capacity for the border force.
I want to pick up those issues of security in a minute, but if you could deal
Yes.
with the issues about recruitment, retention, and whether there is a full complement of staff and what the turnover is at the moment.
Yeah, so I mean, in short, there is a full complement of staff in Border Force at the moment. Over the course of recent years, we have grown Border Force quite considerably.
Is it about 10,000 now?
Yes, bit over 10,000 at the moment, actually, nearer 11 at the moment. Some of that growth has been driven by the growth in the Small Boats Operational Command, which is a part of Border Force organisationally, which essentially didn't exist about 3 years ago, and has grown to around 600 people, as well as growth in other parts of the Border Force. So that recruitment has gone well. We've recruited from a range of different backgrounds, including taking on quite a large number of apprentices across Border Force, as well as people from other roles, both in the Home Office, wider government, and beyond. I mean, as with any big frontline operation, particularly a lot of Border Force work is shift work. There is some churn as people's lifestyles change and that sort of thing, but actually nothing particularly out of the ordinary, and we have maintained that complement. I'm afraid I don't have with me the precise churn rate, but we can certainly provide that to the committee.
If you let me know that. Are you assured that, though, you're not losing a lot of people early on, so you've got a kind of fairly high proportion of inexperienced people who are staying a short time?
Yeah, no, I'm assured about that, and indeed the current Director General of Border Force has been in his role for 3 years. We've got a set of very experienced directors and deputy directors beneath him.
And the training?
So a wide range of training across Border Force that takes place, both as people first join and training throughout. So as well as training in terms of the operations, we do regular training on health and safety and such things. And then for particular teams, for example, teams doing goods searches in the backs of lorries, there are particular training that we carry out on a regular basis. There's a team at the centre of Border Force that maintains that and makes sure we are doing what we need to.
Thank you. Home Secretary, you mentioned increasingly using technology to help with the security aspects of the Border Force's work. Just two questions here, please, if you may. What's the focus on preparing the Border Force staff, training them, in other words, to be able to use those digital technologies effectively? And secondly, whilst there's obvious benefits to that, it has been put to us in evidence that there is a potential danger that as the kind of automation and pre-clearance of arrivals particularly increases through this digital technology focus, there's a danger of losing the ability of officers on the ground using their intelligence to be able to intervene when they are suspicious of people arriving. Do you have any concerns about maintaining the right balance on that?
Well, you're right that we're effectively training people to almost play different roles.
Yeah.
If some of the routine checks can be done, whether that is by e-gates, by the having the ETAs, the ETAs, and e-visas, so you can do a lot of those security checks upstream. It's effectively pushing some of the border security checks further upwards, further outwards. Then that means you can also then deploy trained officers more effectively to spot when there is a problem. And that might be issues around children, for example, safeguarding issues around children. It might be issues around trafficking. It might be issues around stronger customs searches, for example. It might be other areas where just identifying where there seems to be a problem or problematic behaviour at the border as well. So I think it's how you best use the technology in order to make it possible to do the intelligence-based and evidence-based checks. Yes, it does mean training because you're shifting the roles that people as well of having the digitalised approach is it does also mean we can then track when people are leaving the country as well, and whether if they haven't left the country when they were due to, and therefore they're overstaying on their visas. That also allows us to do better and more targeted immigration enforcement action as well.
Thank you. And then just finally, you've touched on ETA. Could you just help us understand how the department is assessing the effectiveness of the ETA system, and in particular, because it's been put to us that a number of people applying for an ETA, the rate of refusal is very, very small. There's a suggestion that the scrutiny in terms of reviewing ETA applicants was not sufficiently rigorous, and that's part of the reason for the very low refusal rate.
Well, obviously the ETAs are for countries which have traditionally been non-visa countries. So they are the countries that we've had trusted relationships with, where there haven't traditionally been problems in the immigration system. And obviously a lot of this is about people coming as tourists in the way that we want people to be able to do so. So I think you wouldn't expect it to operate in the same way or have the same kinds of refusal rates as people who are wanting to come for long-term family reunion or people wanting to come for long-term visas in a different way. I think our understanding is that the assessments, other countries, for example, New Zealand or the USA, have similar levels of refusals as well. So we will keep monitoring this, and obviously wherever we have any abuse of the system, we'll be ready to take action as well. And you'll know, just as an example of this, the areas that we've already had, we've made some visa changes around Colombia, Jordan and Trinidad and Tobago in over the last 9 months, have been areas where different changes to the visa regime had meant we were suddenly getting a big increase in asylum applications, even though nothing particular in those countries had changed. And so we tightened the rules for each of those countries in order to prevent misuse of the asylum system. So anywhere where we have any kinds of challenge or problem, we will continue to monitor.
Thank you very much.
Just on that, on ETA, when this committee looked at arrangements for ETA and the phased rollout of it, we were particularly concerned that information about it didn't seem to be available in anything other than English, and we recommended that there be publication in a range of other languages. Has that happened?
I would need to check and come back to the committee to be sure, but we've granted about 5.5 million ETAs, and there is no indication that people are struggling to apply. But I would think it has, but I can't be certain, and we will confirm for the committee.
Okay, we look forward to hearing from that. Lord Henley.
Home Secretary, thank you very much. The government's made it clear that they want to end the use of asylum hotels by the end of this Parliament, and that's a very specific time, rather than one that can be subject to seasonal interpretation. As you know, we recently saw David Bolt, the Independent Chief Inspector of Borders and Immigration, and he expressed some doubts as to whether the department would be able to achieve that. He said, for example, frankly, I do not think it will be achieved. There is simply not sufficient housing stock to be able to deal with the sorts of numbers that there are in the system. Are you confident that it can be achieved, and how will you go about achieving it?
So we're determined to do this. The asylum hotels, I think, are completely inappropriate, incredibly expensive, but they also reflect the fact that the backlog in the system is just far too high. We should not have this many people in supported asylum accommodation or in the asylum system for so long in the first place. So there's a series of things that we are doing. The most important thing is to clear the backlog. The situation we inherited last summer, last July, it was chaotic because as a result of the Illegal Migration Act, the previous government had effectively halted asylum appointments and decision-making. So we had that final 3 months in the run-up to the general election just plummeting numbers of asylum decisions and appointments being made, sort of 70 to 80% reduction in the decision making. That meant we inherited a rising backlog, and we've had to deal with that, and that has we've had to substantially increase the initial decision making. We now, in the last quarter, was the second highest 3-month period for decision making since 2002, and was more than double the rate of initial decision making that we had in those 3 months before the election. So that is the first stage, to just hugely speed up the initial decision making, just take a lot more decisions to start clearing that backlog. Secondly, we will need to reform the appeals system. The Border Security Bill going through Parliament at the moment does include the new statutory timetable, 24-week timetable around supported appeals. And the Ministry of Justice is expanding capacity in the asylum appeals system. We are looking at ways to go further on that, because it's the appeals backlog that is now increasing, because that system was just not fit for purpose. The next area we're looking at is tighter management of the contracts. You'll be aware we have removed Stay Belvedere from the asylum contract supply chain, and also looking at working with local authorities on more appropriate accommodation as well, working with local authorities on different ways to be able to do that. But the fundamental thing is we've got to get the overall numbers in the system down. And then a final thing that we are looking at as well is stronger checks on asylum applications in the first place. So in fact, there's been a big increase in applications from people who arrived on a visa, including on a student visa, even where there have been no changes in their circumstances since they arrived, no changes in the circumstances in their home country since they arrived. In those circumstances, we are looking at how we prevent some of that misuse of the system, and also how we make sure that there are really robust checks done on whether or not people actually need asylum accommodation. If they have been here working or studying, they should have funding to support themselves and shouldn't be going into asylum accommodation.
As of the 31st of March, and the figures I have, there were something a little over 50,000 open asylum cases. When will you have the next set of figures, and are they coming down?
So the numbers are coming down. The numbers in the waiting for initial decisions are coming down. The challenge at the moment is around making sure that we also can have the same progress around appeals, and that's why we're introducing these appeal reforms as well. But yes, the numbers in the overall system waiting for initial decisions are significantly coming down.
We publish statistics quarterly.
So the June figures will be coming out
in August, I think. So we published at the end of May, the next one soon.
Thank you very much.
Baroness Buscombe.
Thank you. Home Secretary, I want to highlight the issue of organised crime, much of which we now know is intrinsically linked to the illegal boats and supported by a really powerful and dangerous network of criminal gangs who are here and now established in every part of the UK, in our villages, our towns and our cities. It's something that goes unspoken, but it's here and very much alive. The gangs comprise, we don't know how many asylum seekers who've leaked out of the hotels, calling themselves barbers, cigarette and sweet vendors, etc. And they're operating illegally with alacrity. We're all watching it daily, as the risk to them is so negligible and the rewards are so great. The Chief Inspector of Borders and Immigration has told us that, and I quote, in respect of organised crime, the best we can do is deflect it to something else that you are less concerned about, rather than eradicate it. Home Secretary, do you agree?
So I just don't accept that we should accept the presence of organised crime in our communities. I think that what you see is organised crime expands if they are given free rein to do so, and if it is too easy for them to do so. And I think you're right to say that we've had organised immigration crime, I think has been let off the hook for far too long. We've seen that in terms of the way in which the gangs have been operating across Europe, and they have exploited lack of coordination between governments across Europe. But we've also seen organised advantage, I think, of lax enforcement around the high street as well. We've seen that because there really hasn't been a strong enough response on illegal working, hasn't been, I think, strong enough policing, neighbourhood policing in our town centres. I think town centres have been too easy territory for organised crime to operate, whether that be around the organised shop theft or whether it be around organised taking over different high street locations as well. So the first thing that we did straight after the general election was substantially increase the resources for immigration enforcement. So an additional 1,000 people working in different areas of immigration enforcement. That has led to, we've managed to run a 50% increase in raids and arrests for illegal working. And I think it's between a 20 and 30% increase in penalties now going through the system for both employers and illegal workers as well. We need to keep going, and we are setting out and working through different ways to increase the targeting. We're just drawing up a new focus around particularly the gig economy operations, where there's a new measure as part of the Borders Bill, which is about closing the loophole on the gig economy, and meaning that employers need to do employment checks there. And then also, I think the increasing neighbourhood policing, I think, is part of this as well, because we've got the 3,000 additional neighbourhood police that we're putting into place the course of this year. We've said that the focus for police forces this year needs to be town centres. If you've got police forces and neighbourhood police in town centres, then that's when they will get the intelligence about what is going wrong in particular locations as well.
Because the thing is, I mean, my local police community support officer, she's fantastic.
Yeah.
She's covering an area of 120 square miles. How can she do this? And we know that these people in organised crime, they go to quiet areas and no one dare say anything. The Equality Act, I think, needs to be looked at because people are terrified of saying anything. Otherwise, they're accused of being racist or whatever. The other issue, Home Secretary, have you looked at landlords and their role in terms of allowing people to rent who are have criminal intent or there's any suspect of crime? Because that used to be strict liability if one actually was renting to somebody, for example, to do with illegal drugs. Strict liability. None of that is happening at the moment as far as the public can see and feel.
What I would say is crime is crime. Wherever it is taking place, whoever is undertaking the crime, and in terms of policing needs to go after the crime without fear or favour. And we also have the way in which the e-visa system works is that landlords are supposed to do checks on people's right to be in the UK in the same way that employers do and can as well. You'll be aware that we're bringing in a sort of tighter regime around landlords more widely separately as part of the work the MCHLG is doing. But our particular enforcement focus right now is around the illegal working.
Right. Lord Dobbs.
Home Secretary, I wonder if I could just raise a related issue. Do you think identity cards would be helpful to you across the whole range of topics that we're talking about?
Well, one of the things we're trying to do is effectively roll out digital ID for non-UK and Irish citizens. So the way in which the e-visas system works is the e-visa is a digital footprint that will say to anybody, can be checked at any point by immigration enforcement, can be checked by an employer or a landlord, whether somebody has lawful status here in the UK and whether they have the right to work as well. what we're now working to do is to link that and integrate that with the asylum and immigration biometric system, which not only has the biometrics from the e-visas system, but also has the biometrics from Western Jetfoil and for people who are arriving and then applying into the asylum system. And that then gives immigration enforcement, if they have the right biometric equipment, the ability to do fingerprints and biometric checks on the spot and effectively put in place a digital ID system that then allows for much swifter enforcement, much swifter information and intelligence to be able to take action. We link that with the broader system around the entry and exit checks and the digitalisation of the border, and link those things together. That will give us a much better, more effective, data-driven way in which to ensure that the rules are properly respected and enforced.
Very interesting that in your response, the protection of the individual and identity and so on is clearly very important. I just wonder why it is that this government hasn't considered making the theft of somebody's identity illegal, because it currently isn't. Perhaps you'll look at that, but well, I'll leave that for another day. Lord Bark.
Thank you very much, Lord Chair. Home Secretary. I was a Police and Crime Commissioner for 5 years, you may or may not know. And so my question is going to be basically 3 questions around policing. If I can start with this one, many argue that there's been a crisis in confidence in policing in general in recent years. And I refer to a speech you made in November last year, you'll remember it, to the NPCC, APCC, a gathering in London, where, and this is a quote from you, our precious tradition of policing by consent is in peril. Do you still think that it is in peril? And if so, why such? And is it something to do with the lack of confidence among different communities in our country?
So I think this is a really important issue, and thank you, by the way, for your service as a Police and Crime Commissioner as well. When we set up the Safer Streets mission, the Safer Streets mission for the government effectively has 2 halves. So on harm and on confidence. So halving serious violence, an ambition to halve violence against women and girls and to halve knife crime over the next 10 years. And alongside that, the mission to restore and rebuild confidence in policing and the criminal justice system. So on the harm side, the plans we have around the new violence against women and girls strategy, around the changes we've made to take knives off the streets, and on the confidence side, at its core, I think, is about putting neighbourhood policing back on the streets to rebuild confidence. So you're right, confidence in policing has fallen in recent years, and I think that's for a series of reasons. Firstly, I actually think it's about the disappearance of visible policing. So the fact that neighbourhood policing, visible policing has just been decimated. If you don't know your local police officer, if you don't ever see a police officer, you are much less likely to have confidence that the police will be there when you need them. So that confidence issue, and also the taking action on those kinds of crimes that are too often treated as low level, so like the shop theft or like the persistent antisocial behaviour in the town centre. If you see that kind of disrespect and crimes being committed in your town centre at the very heart of your local community, and criminals and vandals just getting away with it, you are much less likely to have confidence in policing. Alongside that, we have had obviously a series of just awful cases where, and obviously you'll think of the terrible murder of Sarah Everard, which actually revealed lack of proper vetting standards and standards in the system. So some issues around standards not being addressed, and issues around different communities having different levels of confidence around policing as well. So I think it's been a range of reasons.
in order to turn that round, the starting point is restoring neighbourhood policing, 3,000 additional neighbourhood police this year, and focusing on town centre crime. But alongside that, as part of our policing reform white paper due later this year, we will also set out reforms around raising standards in policing across the board as well.
Thank you. Thank you. The next question I want to ask is about the great use of technology. Do you think that carries, in police terms, public support? And do you believe, for example, the use of live facial recognition should be placed perhaps on a statutory footing?
I think there are areas where the public might be shocked to know how far back some of the technology is that policing has been using. If you think that the Police National Computer is 50 years old, that means it was modern and whizzy when I was 5. So it's, we've got a problem with the technology, and I think a lot of work to do to upgrade technology. And so that's why I think the work being done, not only around the Police National Computer, around Airwave, and also around looking at new ways to use things like facial recognition and AI. We strongly want to develop the use of AI, and that can be everything from reducing bureaucracy, on things like the redacting information that's needed before a case goes to court, through to using AI to support intelligence as well. Specifically on the facial recognition, some forces have now developed some very effective examples of using live facial recognition. We want to see more be able to do that. There is a concern many forces have about not having a proper governance framework in place to allow them to do that. And so the Policing Minister, Diana Johnson, has been doing a lot of work with police forces and with stakeholders on drawing up what that new governance framework should be in order to be able to allow forces to more effectively use the facial recognition.
Thank you for that.
Just for greater clarity, the question was, do you believe it should be put on a statutory footing? So if we take the current deployment of live facial recognition in Croydon, where for the first time the cameras are going to be fixed to street furniture, that isn't covered under common law, and it's not covered by the one case that's discussed these issues. So there is real question as to whether there is legality for what is happening in Croydon. Don't you think that needs to be sorted out?
So we do think a new framework is needed. So the Policing Minister has been currently drawing up what that framework will look like, and we hope to be able to set out the way in which we would do that more frequently. So we will update you as soon as we possibly can and write to you with the details on that. But we do think you need a new, proper, clear governance framework in order to be able to give forces the confidence to use it with the right standards in place.
All right, my final question to you, Home Secretary, is this. We've all heard, given recent comments from really very senior police officers about the case for reorganisation of police services, police forces in this country, in England and Wales. We're looking forward to the white paper on policing, of course, coming out, we hope, later this year. What's your thinking about this at the moment, and will the forthcoming white paper perhaps include some comment on this?
So the policing reform white paper is being drawn up very closely with policing. We have senior police officers have been seconded in to work with the Home Office on drawing up the white paper. And this has been done very closely in conjunction with both police chiefs, also mayors and police and crime commissioners and others. Been a lot of consultation and development on different areas. We'll obviously set out the full detail when the white paper is produced, but it certainly does need to address the issue that we've got the 43 different forces making 43 different sets of decisions around key things, even issues like around digital structures, digital capabilities being made 43 different times. Some of this is around efficiency and procurement efficiency, if forces can work together in a different way, or if we have national coordination and leadership. Some of it is about the effectiveness of services, for example, forensics or helicopters, air support services as well. And some of it is also about looking again at what should be done at local level, including at very local level with neighbourhood policing, what should be done at force level, what should be done at regional level, and what should be done at national level. So it will include setting out a new national centre of policing to be able to both drive standards but also to be able to draw together some of those capabilities that really should be provided nationally rather than be negotiated between 43 different forces and sometimes 86 different decision makers.
Good. Thank you. Thank you very much. Baroness Burton.
Good afternoon, Home Secretary. Could I just follow on from some of the points that Lord Buck has raised? I mean, firstly, we talk about, and it was very welcome news that now violence against women and girls is a strategic policing requirement. And so, therefore, on the same footing as terrorism and CSAM and as we know. But the funding is so radically different. And I wondered if you could talk a little bit to that. And I say that with the deepest respect, given the anniversary that we're in. But really, you know, given that 20% of recorded crime is violence against women and girls, I think that is a big problem.
We run it.
I have some follow-up questions as well,
yes.
But if we just kick off with that.
So we'll set out the violence against women and girls strategy after the recess. This is the first time we would have done a really comprehensive cross-government strategy as well. So obviously, we're doing a huge amount of work around, from the Home Office led around policing and the criminal justice system and the framework of the law around this. But in order for this to be an effective strategy, it has to go much broader than that. It has to involve education and health and communities and local government and housing and DCIT and science and technology and online issues as well. So this is very much a cross-government strategy that we are drawing up. In terms of the policing, you're completely right. Domestic abuse is both one of the most serious and one of the highest volume crimes that we face across the country. And too often, I think still throughout, whether it's policing, criminal justice system, agencies and organisations, that's issues around coercive control not fully understood and appreciated, and some of those dangers and risks. The new Centre for Public Protection effectively is set up currently in the College for Policing, but to be part of the new National Centre of Policing is a new opportunity to drive much higher standards across the board and also to ensure that we are properly making this a priority right across police forces. Because one of the things that we have to do, given that we know huge amounts of police resource are in fact used to respond to things like domestic abuse call-outs and so on, but not used effectively enough at the moment. And so here it's, rather than us needing to create an entirely new infrastructure, what we've actually got to do is hugely overhaul and improve the existing systems that we have that are dealing with these crimes, often very terrible crimes, on a daily basis. So the Centre for Public Protection is a way to drive that, but it's not the only way to drive that. Putting the 999 control rooms, having domestic abuse specialists in 999 control rooms, that was part of Raneen's law. That is starting to roll out now across the country. The domestic abuse protection orders starting to roll out across the country. And I was going to say something about the review, obviously, that you did, but you may want to ask about that.
Yes, well, yes. I will do, if you don't mind, a shameless plug. I mean,
you should.
32 recommendations I have given to the government, and many of them are around prevention, because we know there is a very, very strong correlation with violent and barely legal pornography affecting real life traits. Not least, 38% of women and girls now expect to be strangled during sex. And could you therefore confirm that the happy news that you are going to criminalise depictions of strangulation in pornography, and confirm that for us today?
Yeah, can I just first thank you, Baroness Petty, for doing this really comprehensive review and for highlighting this, because I think there is actually something really horrific about the evidence that you've gathered, the evidence that we've seen separately about the extent to which we are seeing strangulation in sexual relationships and especially in young people and in teenage sexual relationships as well, that this is always dangerous. There is no safe way to do strangulation in sex. It is always dangerous and with incredibly risky consequences. And the way in which this kind of violence has become normalised as a result of what young people are seeing online, I think is quite appalling and really, really deeply troubling. So yes, we will change the law on this. We will ensure that we bring forward an amendment to the Crime and Policing Bill here in the House of Lords as part of its passage in order to criminalise the possession of porn depicting strangulation, suffocating or choking, because it just cannot be normalised. This is dangerous, and I think young women's lives are at risk.
Well, I thank you very much for that. Could I also urge you, though, in the strategy, when it is announced, that there must be the proposals that I put forward for far greater scrutiny and interrogation of the industry, which at the moment sort of operates, basically standards are not there. I would urge you very much, please, to include those recommendations in that strategy. Just sort of moving on very briefly, though, just to keep on the theme of technology, quite a few people have sort of given feedback who work in the Borg arena that the momentum seems to be tailing off just a little bit, and I want to sort of get your reassurance on that, but also the momentum around safer by design technologies, and I think that you talk about working with DSIT, but I think the Home Office has to be far more involved in this, because clearly there is a little bit of how could I put it, a conflict of interest with the growth surge that they're trying to get out of AI, etc. And perhaps the sort of more preventative, being conscious of what harms can come of it, that the Home Office may have a different view on.
So we do expect the issues around the online safety and issues around the impact that that's having on violence against women and girls to be a significant part of the strategy. And that has involved a lot of work. There is also further work that DSIT have been doing directly themselves around online safety issues, and also specific measures like the issue around the online pornography and strangulation that we're bringing forward, obviously, in the Crime and Policing Bill. So we have, I think, a lot of work really underway across the departments. I think you're right to raise this, because I think the pace of technological change makes all of this challenging, and everybody is having to respond to a pace of change that I think none of us anticipated 10 years ago. And that is particularly about the way in which this affects our children. And particularly around the safeguards, around issues around age verification, all of those things I think are going to become central issues over the next 12 months.
And we have to get ahead of it rather than sort of chasing it down. Chair, would you like me to actually ask the question I was supposed to ask? Yes. The Crime and Policing Bill's in front of us, and VORG, as we've discussed, shop theft, burglaries, burglaries, and child sexual exploitation, and many others. How are the policing priorities set, and is it really helpful to speak of priorities given the many, many challenges that the police face, and in reality they're often set at a local level?
Yeah. So we've tried to frame the priority approach in the Safer Streets mission as being about the most serious violence and about confidence. So the most serious violence we have identified as being knife crime and violence against women and girls. So alongside the violence against women and girls strategy, we also have major work underway in terms of tackling knife crimes, particularly among young people, but not only. So we've got a knife-enabled robbery task force that's been working for the last 12 months, working very effectively to reduce knife-enabled robbery in hotspot areas. So that's the issues around the most serious violence. We do need that to be a policing priority. And alongside that, the other set of issues is around confidence. Now, confidence will obviously vary. Confidence issues will vary from area to area of the kinds of crimes, the kinds of circumstances that are undermining confidence. But actually, the big common theme across confidence, really right across the country, is around lack of visible policing, lack of neighbourhood policing. And I think those town centre crimes have become a real common theme across the country. So that is our focus right now. Neighbourhood policing, I think that visible policing, that's where you build, it's the building block of all of the policing around consent. So that will be a central priority throughout the course of the Parliament. We're focusing on town centre crime now, but as the confidence issues, if that becomes a concern around some other area of crime, that means policing need to adapt in order to respond to that. But that's how we framed it. So the priorities for policing are around serious violence and neighbourhood crime, neighbourhood policing. Beyond that, of course, there are the strategic national priorities like counter-terrorism or public order policing, where all police forces have to have that basic capability in place in order to respond to threat. Thank you.
Thank you very much. Lord Tope.
Yes, thank you, Chair. I'm very conscious of time now. We turn to prisons in the last, our last 5 minutes or so. There's a lot of emphasis now, quite rightly, in reducing prison population. We've had the recommendations from the Independent Sentencing Review on similar grounds. How confident are you that one of the consequences there is going to be even greater pressure on the police service and more particularly the probation service? How confident are you that they're actually going to manage the inevitable consequences of reducing prison size and reducing sentences?
We started here with obviously a prisons crisis that we inherited, and probably the most damaging thing of all, both to public confidence and to public safety, and certainly to the effective work of policing, would have been if we had reached the point where the police could not arrest dangerous offenders because there were simply not the prison places, simply not remand places or custody places to be able to take people to. So I think it would become an essential public safety issue to respond to the prisons crisis. That's obviously what the Lord Chancellor has been doing. That's why we've had the major sentencing review alongside the prison building plan to expand the number of prison places and to strengthen the penalties around non-custodial penalties, strengthen the intelligence monitoring, expanding the work of the probation service. That's obviously led by the Ministry of Justice. We have also worked closely with the Ministry of Justice, particularly on issues around how domestic abuse should be managed, because that raises different kinds of concerns, and we need to make sure that there is swift response to, for example, the breaching of orders as well. So we've been working very closely with them to make sure that those proper risk assessments are being developed and are in place in order to make sure that people are paying the price for their crimes, that people are punished for their crimes, and also that the system is working as effectively as possible to keep victims safe.
I think as a committee we're strongly in favour of reducing the prison population in a responsible way. I think equally we have considerable concerns about the capacity, particularly of the probation service, as it is, of actually being able to cope with the inevitable consequences of that.
I mean, I suppose I should be clear that we are expanding the number of prison places. So the prison building programme is still about expanding the number of places. It will take time. That's still making sure that there is a proper, strong prison system in order to be able to make sure people face proper penalties. The Ministry of Justice obviously leads on the support for the probation service, but the Chancellor has set out additional funding for the probation service in order to be able to respond and to make sure we've got systems in place.
You give me a lead into my next questions. How are you actually working with the MOJ to ensure that there is a consistent message across government about both the need to and the consequences of reducing offending? reducing prison.
There's been a lot of work underway throughout. So the Safeguarding Minister, Jess Phillips, for example, has worked very closely at every point in the response over the last 12 months. So not just the most recent work around the sentencing review, but at every stage in terms of what safeguards or checks needed to be in place, and we're continuing to do so. But I'll maybe turn to Richard, who is the lead for the overall Safer Streets mission, which covers both the confidence in policing and confidence in the criminal justice system as well, who can set out a bit more about the way the Home Office and MOJ have been working together.
Yeah, thanks. It's worth saying, as the Home Secretary said, we have an exceptionally close working relationship with the Ministry of Justice. They are effectively a kind of co-lead on an aspect of the Safer Streets mission because, as the Home Secretary said, confidence in the criminal justice system is one of the two confidence halves. In addition to what the Home Secretary said about Jess Phillips, the Minister for Safeguarding and Violence Against Women and Girls in the Home Office, working very closely with the police. Alex Davis-Jones, who's our opposite number, the Minister for Safeguarding and Ministry of Justice, they've done a lot of joint work together with senior police officers with the Prison and Probation Service to be able to understand both the sequence of releases that have been underway so far, the early release schemes, but also the specific design for how the government will respond to David Gauke's sentencing review. We're also, of course, expecting shortly Brian Levison's courts review, and we're working closely with the Ministry of Justice on that as well.
I think his report's due out. Home Secretary, there's lots more we would love to ask you. It perhaps will be helpful to you to know that in the next week or so we will be publishing a very detailed report on prisons and our thoughts on prisons. We do so in the light of the Chief Inspector of Prisons, whose report has just come out today. We're also conscious that part of the problem of prisons is because of delays in the criminal justice system, and the Brian Levison report and recommendations may or may not prove helpful. The one area that is particularly relevant to this committee's next inquiry, where we're going to be looking at tagging, really ties in at the end to the question Lord Choate was asking about the ability of the police to be able to respond to potential problems, breaches of orders and so on, that may come because of increased number of community sentences and increased tagging. And I don't know whether within your department you've been looking at that issue, and if anybody has, we would like to know who to speak to about that as a matter of urgency. That's a little plug for what we're doing. But Secretary of State, we're enormously grateful to you. You've covered a huge amount of ground in a very short period of time. You've indicated clear understanding of many very different roles, and we're enormously grateful for that. However, you have pointed to a very large amount of, quote, work in progress. So I hope we can get you to agree that in about a year's time you would be willing to come back before us so we can actually see what work in progress has led to. So I hope that will be possible. But I know the committee will have found it entirely useful. I'm sure those people listening in, watching in, will have found it very helpful. So thank you to you. Thank you to your two officials as well. But order, the public evidence session is now concluded.
Thank you, Lord Foster. Thank you for having me.